lot of debate about what decolonisation means, how that might differ from transformation, and how both of those things might differ from transformative constitutionalism. My paper today is not going to answer those questions. This is a very much a practical peg account of what exactly I intend to do in my course next year. It's a paper I delivered earlier at the Teaching and Learning Conference at the University of Cape Town. It was what I was asked to present on there and what I've been asked to present here. So forgive me for not going into philosophical definitions of the concepts I use. I think that how I understand those concepts has been shaped by various factors which will emerge from my paper. So a little bit more about me than what you've heard. I'm a contract scholar. I pretty much only do contracts, but I do it in different ways. I'm obviously interested, contrary to the trend of this particular conference, in the black letter stuff, in comparative law and legal history. That's one strand of thought. I'm also interested in the constitutionalization of contract law, which is a large part of what the background work for this started off as. There's a paper in a book on constitutional contract law. And then more recently, for the last 2 years, I've been interested in the law and society scholarship on contracting, things like relational contract theory, private ordering, transaction cost economics, as well as legal pluralism in the light of the Rhodes Fall and subsequent movements that have arisen. And for me, the answer to what a decolonized law of contract might look like lies somewhere in the trajectory of the law and society approaches to contracting, including legal pluralism. But again, you'll see from what I say below how that evolves. So in terms of the panelists, you've received my paper. I'm not going to talk really to that paper. I'd be happy to speak in question time about the paper, but it's more going to follow the notes that were distributed, which is simply a presentation about legal education in line with the theme of this panel. Which is not to say that I haven't been researching those questions. On sabbatical, I've been researching them extensively, both from the law and society angle as well as from the legal pluralism angle. So an introduction, I said I was going to speak specifically about commercial transactions law. Commercial transactions law at UCT, you can kind of gather what the material is about from the name of the course. It's a final level, compulsory course. It's 72 lectures. It covers credit, sale, lease, the Consumer Protection Act, agency, insurance, insured transactions, and mainly personal insolvency. So basically covers most of the commercial law subjects that you would have to learn outside of company law to be a practitioner in a commercial attorney's firm. The way we teach it, it also has a big amount of relevance to personal life. So we cover topics like residential leases. We talk about consumer contracts. We're all consumers at one point in our lives. We talk about credit in various forms. Most of us borrow money in big amounts, small amounts, everyday amounts. It happens. Buying a house using mortgage financing. Not everyone does that, but a lot of people will do that. Short-term and long-term insurance. The extent to which one participates in the insurance industry differs depending on wealth, but things like funeral insurance are extensively purchased in the low-income market. So I think it also has universal application even to those who aren't going to practice as attorneys. And finally, the law around personal insolvency. One has to be quite rich to be sequestrated, but there are other forms of poor man's insolvency, such as, I would argue, debt review under the National Credit Act, administration under the Magistrates Court Act. One could even start roving off into emoluments attachment orders. We don't have time for that in the course. I think that might be covered in civil procedure. But these are all linked ideas once you get into credit and debt. So decolonization. Prior to 2015, when the movement really took hold, of course these currents had been flowing before then, but less obviously so. We had prior to that tried to make our course relevant to a more general crop of students through a strong influence on consumer law. In 2015, it started with Rhodes Fall at UCT. Immediately, the demand was for decolonization. I thought the best way to find out what does decolonization mean is to throw that back at the students. I asked on our public online platform, what would you like to see as a decolonized curriculum in this particular course in commercial transactions law? And I got a wide range of responses from a wide range of different kinds of people. The general trends can be summed up in three major strands. Firstly, people would like to see a bit more of customary contract law, a greater social justice element. Thirdly, people would like to know a bit more about the comparative law in Africa to do with this particular topic. So what is the law in other African countries on the various issues dealt with in the courts? Customary contract law is a subject more or less absent from all the official accounts of customary law. So if you look in the latest textbooks, if you look at Himonga and Nhlapo, there's a chapter on contracting, but it deals with lobola contracts, contracts related to lobola, certain kinds of labor agreement, not really, if you like, the kind of contract law that one could use in blue chip transactions between, say, corporate parties. It's more transactions that are at home in a kinship setting, which I thought that can't be the whole picture, because the population that lives by customary law must be contracting in their personal capacity. And I think that a certain amount of empirical study is necessary here. So there's a certain amount of work here by economic anthropologists in the social sciences describing contracting practices, and I think a legal contribution is needed. On the social justice front, I think here the scope is for the constitutional contract law intersection. So there's a bunch of cases coming out protecting weaker parties from the Constitutional Court, a lot of which are dealt with in my course where relevant, particularly issues around the right to housing and mortgage, for instance, or the various decisions related to the National Credit Act. There's a lot of work that's being done by the Constitutional Court here to protect weaker parties. And then finally, comparative law in Africa, particularly around the trends towards regional codification. And people are asking the important question, what is African about contracting in Africa? African obviously in scare quotes, because that's a generalization, but what is African about contracting in Africa? What is African about contracting in South Africa? And how does that differ from more universalized trends in contract law, to the extent that contractual transactions often have an international element, or between blue chip corporations, and to that extent might be said to be more or less universal in most countries in the world. So in 2017, what changes am I going to make? I'm going to start with an introductory lecture. So I think that all the topics I list are in line with most commercial norms, are linked by risk management. So we'll discuss the theme and how all the topics related. But I also want to give an extensive account, similar to what I'm giving you now, of curriculum review, how we plan to do it, and outlining some of the factors that I've just outlined. Then, to keep no one in suspense, we'll start straight away with the curriculum review topic, which I intend to do. I intend to focus on the credit issue. So I think that is the topic most studied in this context by social scientists, and we want to look a little bit at the socio-legal literature on credit and debt, on the need for credit in particularly the low-income market, the need for consumer protection. I want to look a little bit at ideas like relational contract theory, non-legal sanctions, enforcement of credit and debt outside of the formal sector, where you borrow from a financial institution. What if you borrow money from someone, one of your friends around the corner, or what if a business that doesn't rely on the law to enforce its credit agreements extends you money? I think these are interesting trends in the social literature and things that need empirical study. Other things we can talk about, of course, here are the National Credit Act. So most people will borrow money as consumer creditors, as consumer debtors, and how does the National Credit Act protect you through things like debt review, through unfair contract terms? We want to look at the control of contract terms, and there are extensive controls on contract terms, both in the common law and the statute law. A particular one, and I'm giving a very brief praise here because time is short, a particular one that we want to look at is the so-called induplum rule. Now, for those of you who can remember your course on commercial law, may remember that the induplum rule is a rule of Roman origin, essentially, that came to us through Roman Dutch law. So it's got an extensive colonial baggage, but it is a form of early consumer protection in that it caps the interest that can be charged on a loan at twice the outstanding capital sum. Now, what's interesting about this, and why I'm making a big deal of it, is there was a big Constitutional Court decision in 2015 which debated an aspect of this, whether the induplum rule should be suspended once legal proceedings to enforce a debt are instituted, or whether it should be lifted. And of course, that has, in an agreement that bears a lot of interest, that can have quite a large effect on the amount of money that is recoverable should an award be made. But what is interesting about it is that the the African judges who sat in the Constitutional Court were debating in detail the proper interpretation of the Roman Dutch sources. You know, there were white judgments given too, but the black judges were debating Roman Dutch law. And for me, that decision was reported at about the time of Rhodesmith's fall. And thought to myself, I thought they were going to play out this Roman Dutch law stuff. I thought this was going to fade away with history. But here it is, right again at the forefront of an important decision by our leading court. So I think that would be a good starting point for a class debate on the role of Roman Dutch law, or the future of Roman Dutch law in contract law in South Africa, given that it is the basis of a lot of our contract law. And I think that we could have a very useful discussion in class around that issue. The rest of the first semester, after this first module on credit, will move to Professor Naudé. She'll deal with sale, lease, and consumer protection with a strong consumer focus, as I've outlined. The second semester will be taught by me. We'll do the core commercial topics, insurance, agency, etc. I'm going to look at topics like microcredit in the first module, but microinsurance. We'll look at the constitutional court decision, the Vodacom one on agency that just came out. The final lecture will be taught by someone called Silindile Buthelezi, who's just come back from an LLM in London. She has said that she is interested in the decolonization of banking law, which is her particular interest. Of course, we'll only know what the outcome of this approach will be at the end of 2017. I hope to report on this in future. Thank you.